Greetings and salutations, loyal viewers of this channel. My name is Sean, and today we got to talk about what went down at a New York appeals court in this videotaped hearing, where you had representatives from the state attorney general's office representing Letitia James and the Trump team arguing about the legitimacy of this fraud case that Letitia James brought against President Trump, which, by the way, was clearly and obviously brought for political reasons as a campaign promise, as Letitia James made it absolutely clear multiple times throughout her attorney general campaign. Now, we're going to get into this. We're going to get into the judges tearing up Letitia James's case right before our eyes, and hopefully this will end up resulting in an appeal victory for the evil orange man. But before we get into that, I want to thank everybody who supports this channel via actualjusticewarrior.com/join.
Give me the money. Give me the money. Okay?
I've taken on powerful interests like developers. I've taken on legislators. I've taken on landlords. I've taken on powerful interest in the city of New York because I believe in a good fight. And right now, what we need is someone who understands that you should not be afraid, not be fearful of Donald Trump. We should take him down. We should sue him all the way to bankruptcy. We should investigate his business interests. We should investigate his business holdings. We should investigate whether or not why he was once in debt and now in a position to purchase all of this property. We can do that because I've been trained to do that, and I will do that at the same time knowing the Office of Attorney General and its powers and its responsibilities and its duties. My name is Letitia James, and I plan on being the next Attorney General of the state of New York. God bless you and thank you.
So this is a clip from August 15th, 2018, where then candidate for Attorney General in the Democratic primary, Letitia James, said that we should take President Trump down, we should sue him all the way into bankruptcy, because of course she is pledging to abuse her powers as Attorney General as a candidate before there's any evidence of criminality, and essentially find something to get President Trump on. Now, there are multiple clips of Letitia James promising to do the same thing. There is one from the Democratic debate before the election.
It's really critically important that everyone understand, as was mentioned by Mr. Bahara, that filing a lawsuit, simply opening up an investigation, can ruin lives. And so with respect to Donald Trump, we need to follow his money. We need to find out where he's laundered money. We need to find out whether or not he's engaged in conspiracy and whether or not he's colluded not only with Putin, but also with China as well.
And there's also her promising to do this to a voter on the street in a video that was posted the day after the election, but may have been shot the day of the election based on the conversation that these two individuals were having.
And what would you say to people who say, oh, I'm not going to bother to register to vote because my voice doesn't make a difference, or I'm just one person?
I say one name, Donald Trump. That should motivate you. Get off your ass and vote.
Will you sue him for us?
Oh, we're going to definitely sue him. We're going to be a real pain in the ass. He's going to know my name personally.
I love it. He probably does already.
And of course, in her election night speech, she also doubled down on this pledge.
I will be shining a bright light into every dark corner of his real estate dealings. And every dealing, demanding truthfulness at every turn.
So already we have an attorney general running specifically on finding a crime in order to get the evil orange man. And again, the links to all these different various clips will be in the description so you could check them out for yourself. But typically, this is not something that is usually done in the American political system. Typically, we don't have prosecutors saying that they're going to just open up cases with the end goal of bankrupting somebody, but let's make no mistake about it, Letitia James did that very same thing. She decided that she was going to use an obscure law that never was used in this manner in order to try to bankrupt President Trump, and she's been celebrating on social media based on the fact that he does not have the actual cash to pay off this fine at this moment in time, and that would force him to sell off multiple real estate holdings or give her the ability to seize those holdings and conduct a fire sale because, of course, For her, justice is all about her political preferences. Make no mistake about it. This is the woman who took down Andrew Cuomo just so she could run for governor, and thankfully, she lost that gubernatorial race, but that's the way that this woman rolls, period, point blank. So unsurprisingly, when her representative shows up to the appellate court to try to pass this nonsense off, before she could even get a sentence out, the judges start hitting her with questions about this particular case.
May it please the court, Judith Vale for the New York Attorney General's office. All of the defendants repeatedly violated—
Ms. Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners, where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence, where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
Yes.
So what I love about this particular clip right here is the fact that this woman comes in from the Attorney General's office representing Letitia James. She has a big ass smile on her face. She's so happy to be here. And as soon as she gets done with her introduction of her name and starts into her little spiel, 5 seconds in, she's interrupted and cut off by a judge who needs to ask the most important question and get her to address that question, which is, when has this law ever been used in the way that you used it? You have two sophisticated partners right here that are equally sophisticated according to the assessment of the judge. You had disclaimers about the inherent subjective valuation of these properties. They did their own due diligence. And of course, the banks do not claim to be victims in this case, because nothing you've submitted in your briefing of these so-called related cases covers this territory. And this woman, spoiler alert, is going to try desperately, but she does not have an answer for this.
These subjective valuations of properties and businesses.
Yes.
And where the victim never complained about any fraud in the transactional losses from it. Because I've gone through the cases which you've cited, and all of them always involved the consumer protection aspect. It involved protection of the market.
Several responses.
And I want to add to his question, and little to no impact on the public market.
So I like the fact that when she starts her response, this other appellate judge says, whoa, I also want to add little to no impact on the public marketplace, because one of the things that the Attorney General's office is attempting to argue is that this so-called fraud in the marketplace is so damaging to the economy overall, and you guys out there in the real world who don't take these kind of commercial loans might be negatively impacted by the evil orange man getting this supposedly artificially low interest rate.
Well, maybe I'll take that first, Your Honor, and work backwards. There was absolutely a public impact and a public interest here. There are at least 4 different public harms from the kind of misconduct here. First of all, when deceptively hidden risks are injected into the market, that does hurt the counterparties, and there was harm to the counterparties here, but it also harms other market participants and the market as a whole because they are not understanding the risks, they are not pricing them in properly, and they are not prepared for what might happen if the true risks come to pass. Also, as the legislature made clear in passing 6312, it was concerned with harms to the honest business people who don't do the misconduct and therefore don't get the kind of benefit that they got here.
I suppose you're referring to the fact that Trump received a lower interest rate than he might otherwise have received. But haven't you yourself conceded that the assets were sufficient to get the lower interest rate of the private wealth management direction?
So I love this. What she said right here is that when you're injecting this unnecessary risk into the marketplace, that does harm the counterparty. The counterparty in this particular instance is the lender, the big bank that lent Trump the money that, by the way, does not claim to be the victim. So what the Attorney General's office for New York State is arguing when they say that is that these Wall Street guys need to be protected from somebody giving them a warning that they're doing subjective evaluations of their deals, because we have to, for the sake of our great Wall Street bankers, protect these people beyond all doubt. Now, the secondary thing is really what the Letitia James case is trying to hang their hat on, which is the idea that this causes irreparable harm that spreads out through the economy because everything in the economy impacts everything else. And by that definition, I actually don't disagree with that evaluation. But the problem is that any interference, any action in the economy will cause some level of interaction, thus a reaction to it, thus a problem in the market. So therefore, according to this statute, Letitia James can prosecute anyone for anything, which is a power that I believe Letitia James definitely wants to have for her political opponents, as she outlined in her campaign. But the fact of the matter is, this actually leads to more potential problems in the market, because essentially any transaction can be subject to, almost 10 years later, the Attorney General Letitia James deciding that she doesn't like you and deciding one of the parties is a victim, and therefore she's going to assess an insane fine in order to punish you based on your political positions and you being in the opposite political party.
But haven't you yourself conceded that the assets were sufficient to get the lower interest rate of the private wealth management direction?
Absolutely not, Your Honor. That is not conceded one bit, and the evidence is to the contrary. If you look at what the Deutsche Bank witnesses testified to, Haig said that the financial strength of the guarantor affects the pricing in terms of the loan. That's in the record at 28167 to 68, and it affects whether the private wealth management group would be allowed to do this deal at all. That's at 28150 of the record.
So one of the things I love about this is that the guy asks a direct question, which is, don't you concede in your assessment of the case that he did have sufficient assets in order to get this interest rate for the loan? This is the mistake, the error priced into the market that has all these different various reverberating consequences. And she says, no, I don't concede that. In fact, if you go to this section of testimony or that section of testimony, here, right there, they say, oh, well, guess what? The net worth of the individual impacts the price of the loan, which obviously nobody is saying that it didn't. But the fact of the matter is, you're claiming that the fraud, the inflated assets are what gave us the price of the loan. But the bank is saying that they did their due diligence. The evil orange man says that they told them that they have to do their own assessments. Like, these are their estimates. Obviously, you have to do your own assessments. And thus, that is what ended up rooting in the actual interest rate in the loan. But this woman right here is saying, no, they said that your net worth impacts the money you get in the interest rate, which everybody knows, and does not specifically address the question. Again, this is what we call a dodge. She probably wasn't expecting to be under this much scrutiny, but this is a case that has aggravated a lot of people in the business world. So obviously, I think that that has an impact, and there are pressures from all these different business people who realize how crazy the power that Letitia James claimed under this law is for this to be overturned.
And you have to remember something. As the net worth as the statements were coming in, the Deutsche Bank was doing a stress test. So if without the fraud, the net worth and liquidity would have started much lower. And then you do the stress test and it takes it down much lower. It does not look like such a strong financial guarantee anymore. It does not look like an ironclad guarantee anymore. And it was absolutely a fair inference that Deutsche Bank would not have given these loans without the financial strength being inflated.
So again, she's making a good argument right here. Essentially, she's saying, look, here's what happened. The evil orange man said, and I'm going to make up numbers right here, I have assets worth $10 billion. And then they ended up doing the stress test from that $10 billion point, and they lowered it, again, just making up numbers, to around $6 billion in terms of net worth. But what this woman is saying is that if the evil orange man would have said that he was worth $6 billion in the first place, then the stress test could have resulted in him being evaluated at $2 billion. Again, just made up numbers right here. Therefore, he wouldn't have got the interest rate. But again, the devil is in the details right there, because she is asserting that. She says it's a fair inference. Let me play that part again.
And it was absolutely a fair inference that Deutsche Bank would not have given these loans without the financial strength being inflated.
And the reason why she's saying that is because they are prosecuting somebody, they are prosecuting a case, they're suing President Trump under this law, despite the fact that nobody is claiming to be a victim in this particular case. So this is all hypothetical based on her making a fair inference that the evil orange man committed this tremendous fraud that destroyed the economy in all these different various ways. Also pay no attention to the fact that real estate is a subjective asset, and this is a common practice, and the bank used their own assessment in order to determine whether or not they were going to move forward with this loan.
That was also evident from Haig and McCarty testifying about the incredible
Doesn't Mr. Hay
collateral.
Doesn't Mr. Hay testify that there were 14 factors and this was the least important factor?
Well, certainly there are multiple factors that go into the risk assessment, but both for materiality and for disgorgement, the issue is not whether there's only one factor. There's often a lot of factors that are being considered.
So these judges are obviously on point in terms of this case, because she ends up bringing up a witness that testified in this particular instance, and the judge right away says, wait a minute, didn't he say that was the least important factor in determining whether or not he would get this interest rate among 14 factors? And she ends up pivoting to say, oh, well, that doesn't mean that I'm arguing it's the main factor. I'm just saying it's a factor, therefore, this is totally justified. But remember, she is saying that based on this fraudulent evaluation, that she can make a fair inference that the evil orange man probably wouldn't have gotten this loan or this interest rate. But the fact of the matter is, that does not appear to be supported by the testimony that she is going off of in this appellate hearing.
But also the financial statements were coming in each year, and they were important, critical to the loans each year, because Deutsche Bank was reassessing the risk every single year, and it was using...
I'm sorry, but what's being described sounds an awful lot like a potential commercial dispute between private actors.
So she's interrupted again with another salient counterpoint, which is what she seems to be describing is what would be adjudicated as a commercial dispute between these two private parties. But the fact of the matter is, neither one of these private parties wanted to get into a dispute over this. They were both happy with the terms of the loan, and in reality, there is no case under this law that she can point to, despite the fact that she immediately pivots to point to those cases. And we're going to talk about them because it is quite revealing what she is citing as a justification in order to go after the evil orange man that she claims is basically the same circumstances, even though they're completely different circumstances.
Well, to go back to the first question about whether there's other examples of this, there are other examples of this. In the First American case, the Attorney General brought a 6312 case where the transaction at issue was between a very big bank, Wells Fargo, and a professional appraisal firm.
But it wasn't the concern there that the public would ultimately be negatively impacted and affected by what those corporate actors were doing.
So one of the things that I find to be incredibly troubling about this particular hearing is how thin the veneer is for the Attorney General's office for the political motivations behind this particular prosecution. Because she ends up throwing out a case right there, which is the Wells Fargo and the, I forgot the name of it, but the appraising firm. And she says that this is a case that involves two sophisticated parties where there was an action that was brought, and this is definitely 100%, don't look too closely into it, basically what we're saying. But in reality, that particular case was not Wells Fargo working against the appraiser or anything like that. Wells Fargo was inducing the appraiser in order to set up these individuals, private consumers, so that they could borrow money for loans that they were not qualified for.
So that's you're pointing to Ernst & Young, you're pointing to First American. Ernst & Young, you're dealing with the collapse of Lehman Brothers. First American, you're dealing with an action brought against an appraiser who overvalued properties at the behest of a lender perpetrating a scheme to induce unsophisticated consumers into taking out home loans that they could not afford. It hardly seems that justifies bringing an action to protect Deutsche Bank against President Trump, which is what you have here. I mean, you've got two really sophisticated parties in which no one lost any money, and that was the point of my initial question. Every case that you cite involved where there was damage to consumers, damage to the marketplace, you've got a scheme to get unsophisticated consumers to take out home loans, you got a collapse of Lehman Brothers, You don't have anything like that here.
Again, this was the two sophisticated people working together, or the two sophisticated entities working together against the consumer, which ultimately ends up being called out later by a judge after a brief period where this woman starts stumbling and bumbling, and inadvertently before that ends up admitting that she's not needing or required to show actual harm or anything like that in these particular cases.
Greenberg for the New York Court of Appeals and Ernst & Young from this court make clear that reliance by a counterparty and actual harm to a counterparty are not required for liability for any of the claims here.
So look, obviously Letitia James promised to sue Trump into bankruptcy as a campaign promise during that Attorney General forum. We have her on tape. She's promised prosecutions of Trump numerous times. It's obviously politically motivated, but the falling back on the idea that the statute is written incredibly broad is not something that should help the New York State Attorney General's office, and in fact should be something that should be used by the court in order to get rid of this statute if they ultimately determine that it is covered, but only due to the vast broad nature of the statute, because that is not how laws are supposed to work. You have to have specific laws that define a specific crime, and the fact of the matter is, writing something overly broad that you could essentially prosecute anyone for anything is not good for the rule of law in this country. And by the way, this woman thinks she's about to be saved by another judge, and he ends up shutting her down after doing so. So I want to play this clip right here.
And the statute is written broadly because the legislature wants the Attorney General to go in and stop fraud and illegality.
Counsel, an example of what you're talking about, I think, is People versus Allen, isn't it? There it was just a dispute among partners.
Yes,
it didn't affect the public, at all. But I think you hear underneath all these questions, the question of mission creep. Has 6312 morphed into something that it was not meant to do? And that's something you must address, because there has to be some limitation on what the Attorney General can do in interfering in these private transactions, as Justice Friedman said, that where people don't claim harm. So what is the limiting principle?
Well, I'll say two things, Your Honor. Well, first of all, the limiting principle are what's in the law. So the illegality claims require intent. They require materiality.
Let's talk about the standalone.
Just for the 6312 fraud. Well, this court has defined that rather broadly, but there are still limits. It is not falsity in the wind, first of all. It is not falsity that you whisper to someone on the couch. It has to be related and relevant to the business at hand.
So yeah, he asked one of the most important questions, which is about mission creep and about whether or not this law is beyond limits, or the Attorney General is using this law without any real limits. And she ends up saying, oh, well, the limits are related to the statutes, the penal code, and all that. And he's like, beyond that, we're talking about the standalone. And he presses her on that. And then she says, look, it has to be with the intent to deceive, the intent to fool. But the fact of the matter is, if you say, these are my subjective evaluations of my own assets, but also do your own assessment, as I know you will, because this is a transaction between two sophisticated lenders, and neither lender is upset about this, where's the intent to deceive?
I notice you say the ordinary standard on page 55 of your brief. You say these deceptive strategies had a capacity, a tendency to deceive, because they would have been relevant to and likely to mislead an ordinary person involved in the business dealings, and you cite to General Electric. Mm-hmm. Isn't the test here whether they were likely to mislead Deutsche Bank or Ladder Capital or the City of New York awarding a golf license, or Zurich on a surety bond program, or Everest National Insurance Company on a directors and officers policies? The defendant's statements were not meant for ordinary people. They were directed at some of the most sophisticated individuals and entities in business.
Now, this is where they end up getting into the issue of the fine that they assess to the evil orange man and how it happens to appear rather excessive. And of course, she's going to defend that in all her different various ways. But as you could see, this is also something that is of concern to many of the judges on this particular panel.
I have a question that's similar to Judge Rosado's, actually, which is the immense penalty in this case is troubling. So how do you tether the amount that was assessed by Supreme Court to the harm that was caused here, where the parties left these transactions happy about how things went down?
So yeah, this is where we're at in terms of the Letitia James fraud case, and obviously there is concern not only about how this case was brought, the statute that was utilized, and of course the penalty that was assessed, but also there has to be some background concern about the political motivation behind this, because Letitia James quite literally campaigned on suing Trump into bankruptcy. That's what she said she was going to do way back when she was a candidate, and wouldn't you know it, that's what she has done or attempted to do while she is in office. So obviously very questionable circumstances for the evil orange man, and I do want to point out that there are smaller related issues to this where the evil orange man appears to have done things that are wrong, which involved objective realities, not subjective reevaluations, like overestimating the square footage of a penthouse. Also, he had different various apartments that had rent stabilized units, and it appears on his paperwork he indicated that they weren't rent stabilized units.
And that any reasonable counterparty would want to know. Any sophisticated, reasonable counterparty would want to know that the defendants were valuing an apartment based on 20,000 square feet more than it really was, based on pretending that rent regulations on certain apartments didn't exist, based on pretending that the Mar-a-Lago restrictions didn't exist. Your Honor asked about that. The trial court was very clear that it was not coming up with a magical valuation for itself. The problem with the Mar-a-Lago valuation is similar to what happened with the rent-regulated apartments. The restrictions in the deed are there. They are an objective fact. They are very restrictive.
And if the Attorney General's office actually limited the scope of this fraud investigation to those specific things rather than the broader case, we wouldn't be having this conversation. We wouldn't be talking about this video. But the fact of the matter is, she used an obscure statute in a way that it has never been used. None of the cases support that there's any precedent for this, in order to go after a political opponent and then assess a devastating fine that is many multiples times the profit that the evil orange man would have made on this particular transaction, again, according to their own representative.
The proceeds of the loan of the sale were around $370 million. The trial court took out the repayment of the Deutsche Bank loan, and I think defendants themselves had taken out already the taxes. And Mr. Trump testified that the number for him, around 126 million in profits, was his profit. That was his profit or more.
Now, look, I'm not sure how this appeals court is going to rule. We might be in for a long process that ultimately ends up in the Supreme Court. But for now, that's where I want to leave this. Now, as usual, if you like the video, show them by leaving a like, subscribe for more content, follow me on my social media, support me via the support links in the description of this video. This has been me talking about an appeals court essentially tearing up Letitia James' representative. Till next time.